Miguel, do you want them to be using the mic up here?
Either one is fine.
Okay. Sorry for the delay, folks. We had slight technical difficulties and we ran over a bit the last panel, but I'd rather allow the conversation to play out fully and run a bit late than cut things short. There is a reason that we started the conversation today with a panel on alternatives to detention, and that's because detention should not be the default. We're going to discuss appropriate conditions here in this conversation, but I want to be clear that our presumption is that individuals should not be detained in the first place without an individualized assessment, reviewable in court, of the need to detain for reasons of public safety or flight risk, which would require Congress to change the immigration law, as well as a finding that less restrictive alternatives to detention or other forms of lesser supervision cannot mitigate flight risk. Detention should not be the default enforcement tool in either the immigration system or the criminal justice system. Removing a person's liberty or libertad, even under civil authority, is a serious thing. In March 2010, ICE Director John Morton said, quote, "I intend to change the jail-oriented approach of our current detention system and am in the process of redesigning the system so it meets our needs as an agency that detains people for civil, not penal purposes." Our purpose today is to talk about what such a system might actually look like. First up, we have once again Dr. Dora Schriro, former director of the Arizona Department of Corrections, former special advisor to DHS Secretary Janet Napolitano, and current commissioner of the Department of Correction in New York City. Dr. Schriro will be followed by Dodie Ledbetter, who is deputy court administrator and former detention director for the Pima County Juvenile Court Center. And then we'll have Victoria Lopez, program director of the ACLU in Arizona. And finally, a very different and useful perspective from Greg Cook, senior associate and senior designer in the Justice Group at HOK, which is an international architecture firm based in St. Louis. Dr. Schriro?
Thank you. Good morning again. So I want to pick up where I left off. In 2009, traveled the country, looked at 25 facilities, went to some facilities more than once, talked with all the stakeholders in each of the places where I traveled, and of course, wherever I went, talked to any number of the individuals who were held by ICE, as well as the staff who were operating those facilities. In 2009, there were, in the course of a year, 383,000 individuals who were held for 1 or more days by ICE. And last year, in 2011, that number had increased to over 429,000 in the course of a year. In the several years that have also passed, a number of the recommendations for reform that I made have been adopted, and I'm going to talk a little bit about that. As pointed out in the wonderful publication that Human Rights Watch had released last year, they observed that there are 4,622 to be exact, beds that have been remade in a model that moves closer to a notion of what civil detention, and as I would like to suggest it ought to be considered civil detention, would look like. And so those 4,600, give or take, make up now 14% of all of the beds. And so it's a great first step, but there's clearly much work to be done, not only in the evolution of the model, but then its integration across the country to the extent that detention is warranted at all. And since that time, the 2011 standards, again, still predicated on ACA, jail standards have been released, but the number of facilities that are required to adhere to those standards is still a relatively small in number. I want to go back to the analysis that I provided in the report to give us a frame of reference, because the conversation inevitably toggles back and forth between the civil versus criminal models. the criminal model is important for informing and providing a frame of reference, but it's not intended ever to be the template, something that you just copy and then replicate wherever you go. And so, as in everything else, knowing what is similar versus what is the same is going to be really critical. As I went around and talked to people and toured facilities, I was trying to look for ways to sort all the information I was collecting, and ultimately the way that I did, and I've presented in the report, and I think it's useful, this conversation, is that there are basically 7 buckets for assessing how well a system is operating. And so when it transitions from dealing with a population health for the purpose of either determining innocence or guilt or administering the punishment, which is isolation from the community, versus making a determination of removal or relief, these 7 buckets still apply. First is what I've been referring to as population management. And these are the core assumptions about whether or not a person should be held and the conditions under which they should be held. And so it goes to Ruthie's core point about should it be release with no conditions, release in the community with conditions, or placement in a facility, and then if in a facility, how secure should that facility be? Because in all things, it's not a one-size-fits-all. There's a continuum. And for both efficiency, which was the judge's point over and over again about is what we're doing not only effective, but is it efficient? Are we using our scarce resources wisely? We all know what we could do with that money if we weren't spending on this thing then for something else. And so population management is really those core premises about where this person should be along a continuum. And the next is for those who are either placed on community supervision or sent to a detention facility, a civil detention facility. Again, what are those assumptions about day-to-day management of those individuals, which goes from no management at all, they're perfectly capable of running their lives on their own, to individuals who need to be regulated in a variety of ways, and again, based on the very same premises that Ruthie said, either because they presented risk to somebody else, which is the propensity for violence assessment that I talked about in my opening remarks, or what is their risk of flight, failure to appear for a scheduled appointment if they were placed in the community. That second bucket is referred to as detention management. In both aspects, and in the other bucket that I'm going to touch on briefly, ICE, certainly in 2009, struggled considerably to carry out population management and detention management with the same kinds of skills, with the same kind of infrastructure, with the same kind of abilities that most correctional systems evidence. And I'll just pause for a moment. At the time of my review and report, what is now referred to as ERO, or enforcement and removal operations, was referred to as detention removal operations. And I think in part because there was so much attention brought to the difficulty with the day-to-day management of detention that they changed the name. And it is a much more accurate reflection, but it is one of the core challenges that we all face, both in government and in the advocacy community, about making these changes happen. That whether you're going to continue to operate the system based on the correctional model, which I never advocated and I expect others don't as well, or if you're going to toggle to a civil model, which is still the process of being invented. Isn't that a great opportunity for all of us? That there has to be expertise inside of government to drive this, because if there's no expertise there, then it will come from the outside. And this goes directly to a panel that I'll be talking on later today about our total reliance, government's total reliance on others other than ICE operating all of the detention facilities, and to some extent others than ICE also operating the alternatives, the community supervision. The The next of the big buckets is programs management, which we touched on in the previous panel, and again, currently built solely on an understanding of how jails and prisons operate, programs being narrowly defined based on case law in the corrections arena, law libraries, religious services, visitation, and recreation. The in-programs management, the most important program of all, so creating its own bucket, is healthcare, something that we haven't touched on today, except for the obvious mental and physical effects of being detained, whether it's criminally or civilly. But healthcare is an area of great concern as well, and I'll go back to that in a moment. Special populations is important, and we've already heard this in Margot's remarks, but more broadly, that both on the correction side and on the civil side, whatever you do, it's not a one-size-fits-all, that it has to be adjusted for everybody that is in the system. So in the most basic way, just as you have low, medium, and high custody, and that's one form of adjustment, where you have females who are held as well as males, that there have to be adjustments, whether it's the kind of health care that you deliver or the different nutritional requirements, in the most basic way, but other important differences that distinguish men from women. But as we heard with asylum seekers, that is a special group with a variety. Back again to customizing population management, which includes alternatives, that for individuals who are initially, as a matter of mandatory detention, components of immigration law, ineligible for placement in the community, at a point when they've made an effective presentation of credible fear, and so they're eligible for movement to a community setting, that the system is really set up to prepare them, as we heard is occurring in Pima County in Tucson, to really get them set up so that they can now make an application for community placement and be successful in the community and still meet whatever reporting requirements that they may or may not have. Of all the buckets, and the one that really goes through all of today's conversation is the one that I call accountability, which of course is the core responsibility of government, to be accountable to its authorizing environment. So for everybody who votes in an administration, for everybody who pays taxes, for everybody who lives and works in a place, to be transparent in all that we do, to be accountable in all that we do, is the last of the pieces. So having laid that out, I want to talk a little, give some examples of how detention predicated on a criminal model was operating several years ago, and some of the movement that's occurred. And so then in the big silence is what is left to be done, and it's for you, of course, to fill in those blanks yourselves. So population management, again, which is just being sure you're set up to actually manage everyone who is under your authority, for whom you have responsibility for their care, custody, and control. Some of the very basic things that were missing in 2009 was just having one comprehensive list of everyone who was in ICE custody on a given time. The number of stories and accounts about families having lost track of someone and not knowing if they had some bad had come to them, or if they had been taken into ICE custody or arrested and were maybe under some criminal justice authority. And so today, it's great to report that there is a updated daily available on the web list, so that if you're an attorney looking for a client or a family member looking for a loved one, that you have this very basic instrument that is universal throughout correctional systems. Something that is still needs attention, however, is likewise having a roster of all the facilities in which individuals under ICE's authority may be placed, but more specifically than having that list is being able to identify in advance whether or not those facilities are appropriate for, again, the core questions, low, medium, or high custody individuals, people who present risk to self and others, as well as risk of attempt of escape in this case. But also whether or not these facilities are suitable for individuals who have medical needs. Are they close to 24-hour emergency care? Are they staffed around the clock with the kind of healthcare providers so as to accommodate the individuals who may be placed there? ICE is still a largely decentralized, largely regionalized operation. There are 24 field offices around the country, and it's primarily the responsibility of each field office to procure the beds within their catchment area. But because capacities vary place to place, and because the system is not as tightly coupled as correctional systems are, where from headquarters you know everything, you know all of those kinds of things about any facility at any point in time, where there are vacancies and for whom those vacancies are appropriate. ICE is still largely set up where if you run out of beds in one region, or if your case is moving slowly, so you're then moved to a region further away, which happens on an increasing basis, which goes back to a question, I think it was yours this morning. It's still creating the infrastructure so that you are right-sized to the extent that there must be detention, that you have the right number of beds in the right locations, so as to meet the needs of both the system, but all the individuals in the system as well. I'm going to go over for a moment, because I know I've run over already, but with healthcare as another example about where there are lessons to be learned from the correctional side, but they should not be adopted wholesale, but again tailored to the unique needs and just fledgling case law that's coming up on the civil side, is in the area of healthcare. Because the assessments that are made, to the extent that they occur at all, happen after someone is assigned to a facility, it is then largely, if not wholly, incumbent on the largely incumbent on the receiving facility, which is going to be operated either by a sheriff's department or by a private prison provider, with very, very few exceptions to either of those delivery systems. It's up to them to make the assessments and to determine whether or not that person is appropriate. And where untoward things have occurred in ICE, particularly in the area of medical care, it's because the receiving provider either failed to assess that person was beyond their means to serve, or for some other reason didn't communicate it back to ICE. And so some assessments need to occur prior to assignments, which is the ordinary case in the way jails and prisons are operated as well. And if then the status of the individual changes over time because there's some emergent medical requirement or some marked shift in their risk assessment, that there be a mechanism where they can then be transferred to a place that is appropriate to meet those emergent needs. One of the other things still a number of things that is missing in the area of healthcare, as we really are building a system from ground up, as well as reinventing it at the same time that we are inventing it, is with medical records, which at the time were created when one arrived at a facility. But if you were transferred, that a medical summary would go, but never the full medical record. And so if you were moved on 2 or more occasions, you never had a complete medical file. And similarly, for those who were returned to ICE detention at a later date, and that did happen with some frequency, you started anew. And so again, whatever the system had learned about your medical or mental health requirements, it was largely lost because it stayed at the place where you were last. And so there was never this whole look at a person. You were slices of individuals over time, and that of course it creates liability for a system, and it also places the individuals in the system at real risk as well. So I think that's plenty for now. We'll do the rest in Q&A.
Oh, I think I'm next. I feel a little bit like a fish out of water. I am the Deputy Court Administrator at Pima County Juvenile Court. I work with kids. I've worked with kids in an institutional setting for approximately 19 years. And I've worked at the court for 23 years in a variety of positions. So I think that the first thing I'd like to do is to thank Human Rights First for this invitation. That was surprising to me, and certainly to thank Evelyn Cruz and ASU. Please understand it's difficult to thank ASU, being from Tucson, but I sincerely do thank ASU for this. When I was invited to today's program, I thought, what could I provide of value regarding kids charged with immigration violations, because Pima County does not hold kids for immigration violations. There are facilities in the state that do hold kids for just immigration violations. We do not. We do not have a contract with the federal government to hold kids, even on criminal charges. That's very unusual, but we don't do that. We don't do that because it's been sort of a reform practice for us in the last few years. The other piece is our standards don't allow us to hold people for immigration violations only. And certainly we have a lot of those issues. We've had kids who have been arrested and brought to us for shoplifting, whose mothers have come across the border without the proper papers. And the kids have been brought to us, and if mother appears, mother's going to be deported. So we try very hard to figure out how to convince mother to come in and be deported with their daughter or their son, so the family can still stay together and at least go back across the border together, rather than being split up, where we have the daughter or the child and the parent is returns to their home country. And a lot of those cases end up in Child Protective Services, and they are not capable of handling this type of situation. So I read the jails and jumpsuits review, and that's where it struck me. We do have something comparable in juvenile justice that you're trying to do right now. We've been across the country. There have been juvenile detention facilities that have been involved in major reform initiatives. And the one that we chose was the Juvenile Detention Alternative Initiative from Annie E. Casey. It really mirrors a lot of things that we've talked about today, and the efforts that are made in the recommendations and the next steps in this report. But one of the things where we really got in tune to what we were doing with kids was our budget. Now, we have to be accountable to our budget. Our juvenile population that we were locking up in Pima County was 177 kids in about a 110-bed facility. We advocated, bribed, cried, begged to get a new facility built, and we were able to get a new facility built, and with that, we decided to use the National Institute of Corrections direct podular supervision model to start looking at how we manage our youth population. From there, a few years later, we took on the Juvenile Detention Alternative Initiative, from Annie Casey, which really focuses on 3 primary factors, and all of them have been talked about today. A risk assessment, a validated risk assessment that makes you look at mandatory reasons to lock people up. It really makes you analyze the purpose of that, and if you really are providing safety to the community. What we found out was that locking kids up is the least effective and most expensive way to guarantee public safety. I think that probably toggles over, to use Dora's word, to the system of civil detention. It's very expensive, and again, if we were able to hold federal government and agencies to their budget requirements, they too would have to look at it the way we did. So the risk assessment, a validated risk assessment that talks about the only 2 reasons to lock somebody up. The only purpose of detention is to keep somebody who's a risk to you and I away from us, to keep somebody, to guarantee that their presence at the next court hearing. And certainly when you're talking about immigration violators, you're talking about possibly an elevated risk of not reappearing for the court hearing, although I don't think the facts would support that. I think if you provide a system of support for those people when they're released, they will have an investment in returning to court. So it's the risk assessment, it's the conditions of confinement. What is it like in your facility? Do you meet basic standards? And then your alternatives to detention. It goes along very well with what is really the basis of civil detention. So we went through all of those processes, painful as they were. We are using that model as the foundation for the way we conduct business. The other piece that we use for our kids, the real key, other than not locking up kids who are not a risk to you and I, and actually having alternatives to detention, which are for us in Pima County approximately $7 a day compared to approximately $300 a day to keep a youth locked up. We tried very hard to normalize the environment that we were moving into. Our new facility, we wanted it to look a lot different than the old facility. So we too looked at routine, very rigid and almost militaristic processes that we did with kids to try to normalize what they were doing. So for instance, kids would walk with their hands behind their backs, their heads down the hallway. That really bothered most of us because we like them to hold their heads up high. We like them to talk to us as we're walking down the hallway with them. So we basically said, your hands are free and your head needs to be high. We then changed their uniforms, which were very institutional-like uniforms, to khakis and multicolored polo shirts, which the colors reflect the levels of behavior the kids are at. And basically everybody comes in at a high level. You don't start at an observation level, you start with everything. We started changing the institutional furniture. If I had all the money that we paid for institutional furniture, we wouldn't be here. It's extremely expensive, unattractive, uncomfortable, and it doesn't build relationships or improve behavior with kids. So we're still in the process of changing some of our institutional furniture. We've done things where we don't have grassy areas, which some of the facilities that have become, the 3 that are mentioned in the report, really talk about giving people choices and giving people freedom to movement, at least a little more freedom to movement. Our facility is not built for freedom to move, but we do allow kids to walk the hallways without an adult. We can, of course, monitor them by camera, and we can monitor them as they're walking up and down the hallway. But we do allow them to make more choices in programming, more choices in activities. We've given them a lot more natural light. more outside activities. We've improved visitation, which is something civil detention also needs to do. It needs to open up its visitation to all parties that are involved with this person or this family. We redefined family so we could broaden the scope of people that could visit our kids, because our kids don't get many visits, and the more they get, the better they behave. All of this normalization, all these efforts to normalize the facility did exactly what we hoped it would do. With NIC direct podular supervision, with JDAI conditions of confinement, we were amazed at how the benefits, the cost benefits, the disruptive, the lack of disruption, the relationship development that happened in our facility. It doesn't cost us as much. We have very few graffiti or broken pieces of equipment that have to be fixed. We have very few fights. We have practically no assaults on anybody for any reason at all. The kids have very different relationships with staff. Staff have very different relationships with kids because the surrounding is so much more normalized. It's still a detention center. Still has locked doors, still has very strong brick walls. It will survive an earthquake. But the internal environment, which we have control over, is the same internal environment that jails and prisons have. When you talk about people who are violators of a civil law, not criminal violators, not delinquent violators. So when I read the report, I thought there was just a lot of similarities in the movement for reform. The Arizona Supreme Court, through its office of, or its administrative office of the courts, is facilitating with 4 other juvenile courts in 4 other counties in Arizona to bring those reform initiatives to those counties. Some of those counties hold kids for civil immigration violations. They won't when this initiative is adopted because it's against the conditions of confinement. So our conditions of confinement, really, I learned from this, and we're going to make some further changes because of the report. We don't have plants in our juvenile detention centers. We don't have them inside the living room where the kids are. We do have a garden. We have no dirt. We had to bring in dirt because we have cement. But we brought in dirt for a garden. Now we'll be bringing in plants that kids can work on in the units themselves. So when you look at changing detention or civil immigration violators, moving them from a penal institution to a civil detention institution or to release to the community with the proper supports to support them returning to court, it's a huge financial and people resource commitment from the community, from the country. But it doesn't have to be, because we don't have to build new institutions. This country has lots of vacant motels, hotels, casinos, college campuses, dorm-like facilities that can be remodeled, that can be used to house people in areas that are more urban so that people can get their legal representation. What we did in our facility was like every facility. You have times where attorneys can come in. You have times when you can see the doctor. Basically, our kids can ask to see the doctor or the nurse anytime, and we're going to take them to the doctor or the nurse, or they're going to come to the unit. They're there on site 24/7. Attorneys, we will pick up the phone at 2 a.m. in the morning and call their attorney if that's who they want to talk to. Their attorney can come anytime. We like them not to come at bedtime, but anytime to see the kids, to have access to the kids. It builds some self-esteem in our kids. It teaches them their rights. We help them exercise those rights, even though when oftentimes we're the violator of those rights. They get to hold us accountable to that. But civil detention, changing from a penal institution, really goes along the same lines of juvenile detention, moving from an institution that was really built on the criminal justice system to one that recognizes adolescent development or lack of adolescent development, brain development, capabilities, and looking at an individual assessment of not only the kids but of the adults now that are in civil detention or non-civil detention facilities. So that's basically what I learned from this report, and I thank you very much, and I hope you enjoy the rest of your day.
Can I ask you, Dodie, one question before we move on? If you could just describe the length of stay, what's the case status of the particular population we're talking about, just so we have that context.
Sure, and thank you for that, because now I get to brag again about our risk assessment, which has been validated. From 177 kids, we had 43 kids yesterday in detention. When I moved back to detention some 100 years ago, we had 48 kids in one living unit that I was in. So now we have less kids in 6 units than what we did about 10 years ago. Our age ranges from 8 to 17. We very rarely, thank goodness, get an 8-year-old. Anybody under 10 or under, you have to have the director of the court's permission to detain. Thank goodness we don't get most of those kids. The charges our kids come in on have to be delinquent charges. They cannot be runaway. They cannot be ditching school. They cannot be minor in possession of alcohol, even though that is a civil offense. We don't lock kids up for those behaviors. We have an alternative to detention that deals with the domestic violence kids who are charged with domestic violence, who are not locked up in our facility. They're handled through the mental health system and processed as paper referrals or ticketed kids, which is much more effective, a lot less expensive than locking them up in detention. So our kids in detention, 50% of them are in there for either warrants or violations of probation. So they've been adjudicated and they've been placed on probation. The other 50% are in there primarily for substance abuse charges, car theft, disorderly conduct. And most of them have real extensive histories with the court. Most of them, 47% of them, have one or more mental health diagnoses, which is not any different than our penal system in this country. Most of them do very, very poorly in school. They're very, very high needs kids. They haven't been in school for a long time. They are very unsuccessful in school, and they have parents who have real serious problems in the community. Not just substance abuse, but lack of upward mobility. They're poverty, they're in poverty, they're single parent households headed by females. It's a difficult population to work with, but when they're in that facility, they are children.
And average length of stay?
17 days, which is creeping up. And our average age is creeping down. Neither are good signs.
Thank you very much. Victoria? Yeah,
So I wanted to go back a little bit, because both Dodie and Dora spoke a little bit about this balance between the civil and criminal detention worlds, and just back up a minute to talk a little bit about the applicable legal standards for both, and then use our work here locally at the Pinal County Jail to highlight some of the problems that we see here locally with using a jail setting for immigration detention, and also some of the challenges with litigation and some of the opportunities maybe with non-litigation advocacy and organizing strategies within the jail to be able to expose some of the abuses or some of the problems that are happening inside of detention facilities, and raising awareness and hopefully making some significant changes. So generally, the applicable legal standard when we're talking about the balance between civil and criminal worlds, the 5th and the 14th Amendments protect civil detainees in state and federal proceedings, and that includes immigration detainees. Civil detainees are generally entitled greater constitutional protections than convicted prisoners who are protected under the 8th Amendment, and that's because they haven't been officially convicted of a crime. And the duration of a detention bears some reasonable relationship to the purpose for which the individual is detained. So again, going back to some of Dora and Dodie's comments about the balance between the why and the how and under what circumstances and conditions an individual is detained. In the Ninth Circuit, there is a case called Jones versus Blanas, and Jones is a case out of the Ninth Circuit that recognizes that constitutional protections afforded to civil detainees, such as immigration detainees, equal or exceed the rights conferred on 2 other categories of individuals. Individuals detained under a criminal process and people who have been convicted, so post-conviction prisoners. In the Ninth Circuit, then, unlawful punishment is presumed when civil detainees are held in conditions similar to the conditions that pretrial civil detainees are held under, which is actually what we've observed at Pinal County Jail. The conditions at this mixed-use facility are equal, regardless of whether you're a pretrial detainee going through some type of criminal proceeding or you're a civil detainee facing immigration or removal proceedings. The conditions, the surrounding, the staff, the circumstances in which you're detained are exactly identical. So, of course, at the ACLU we think about, how can we challenge this? This seems clearly wrong in the Ninth Circuit, and how do we work up some litigation, right, that challenges what's happening at Pinal County Jail, because clearly under Ninth Circuit case law, you can't hold immigration detainees in the same conditions as pretrial criminal detainees. It's hard. It's hard. Litigation isn't easy. Litigation is not always the answer, and it takes a lot of work and a lot of resources and plaintiffs and fact gathering, and it's hard, right? So, you know, can't go into court with guns blazing all the time. Not even in Arizona. So, we at the ACLU 3 years ago started an investigation into immigration detention in Arizona. It was a very broad project. It was a very broad investigation. I came onto the ACLU 3 years ago and was told, let's look at immigration detention in Arizona. What does it look like? Who is in detention? Why are they in detention? How long? What is the impact on their family, on their community? Why? Why is this happening? We keep hearing about the growth of the immigration detention system. What is happening here in Arizona? So, we started talking to people in all 5 of the detention centers that are spread across Eloy and Florence. We went in, we spoke to people who had been detained anywhere from a couple of weeks to 7, 8, one person 9 years that I spoke to, just like Marco. And so started talking to people about their experience, how they ended up in detention, how long they had been there, what the conditions were like, what the impact was like on their community, on their families. And it was, sort of, to back up just a minute, Pinal County Jail has kind of been in this contract with ICE since about 2005. And in the time that I had been working with folks in detention in Arizona, this was really the first time that I had seen a coordinated effort to get information out of the jails by detainees. And it was really amazing. It was this letter that explained what they had gone through, why they objected, how they wanted it changed. And they sent the letter to the ACLU, to Amnesty International. They sent it to the Inter-American Commission on Human Rights. They complained about the lack of medical care. They complained about being verbally and mentally abused by sheriff's officers at the jail. They complained about lack of sanitary and hygiene supplies. They complained about not being able to go outside, having no outdoor recreation. They wrote about food quality, poor food quality, a lack of food. They wrote about not being able to visit in person with their family members, so not having contact visitation. And this was in 2008, around 2008, 2009, that these women wrote this letter. And so we decided that we needed to take a closer look, specifically at the jail. And the jail is a contract with ICE for 625 beds. And sort of the population trickled in slowly at the jail, starting at about 50 people, then 75 people, and then increased and increased. It initially was male and female, and eventually was phased to only men. After the women had written their petition letter, and after the Inter-American Commission on Human Rights came out on a fact-finding mission to Arizona and included Pinal County Jail on their agenda and spoke to the women at the jail about the conditions. And unfortunately, just as late as last Friday, when I was out at the jail doing visits with people and talking to them about the conditions and some of the issues that are going on there, they mentioned many of the same things that the women had written about 3.5 to 4 years ago. So we've seen multiple violations like the ones that the women mentioned. The one that folks most complain about, the folks that most people are just devastated by at the jail, is not having outdoor recreation and not having contact visits with family members. And so at the jail, there is no outdoor recreation area, if you can imagine. It's a room that's sort of built up really tall, and it's indoors, and it has concrete flooring and a basketball hoop. And probably last year, ICE put in some stationary workout equipment, and then there's sort of mesh kind of gate above, on one section of the wall, sort of above, kind of high up, meets this kind of the ceiling of the room. And so that's the only outdoor recreation area that is available to detainees at the jail. So there have been people we've worked with and spoken to who've been detained there for months or years who have never seen outside, and maybe Marco already talked about this in his experience, but clearly that is punitive, that is harsh, that is something that no person should have to go through for really any period of time, but especially not for months and years on end. And the other piece, of course, is not having contact visits with family. So all of the family visits at the jail are conducted through a video conferencing system. And what we saw when we started talking to people is that often families just didn't schedule visits anymore because it was awful and painful to have a half an hour, sometimes less, depending on what was going on at the jail and if a visit could be accommodated or not, to just have a little bit of time to talk to your family member through a video screen and not be able to give a hug or give documents or any of those things that you would imagine you would want if you were in jail separated from your family for that long amount of time. We also, of course, saw inadequate sanitation and inadequate hygiene items. We also heard a lot about verbal abuse by guards at the jail. So the jail staff at the Pinal County Jail deals with both, again, the pretrial detainees as well as the immigration detainees. Certainly this is not acceptable under any circumstance, but it's something that we've heard over and over about mixed jail facilities, that the staff often do not know the difference between the types of people or the case scenarios or the types of proceeding that the folks who are in the jail are going through, and so just treat everybody equally terrible. And we heard from ICE detainees that guards in the jail would say, we don't really care if you're here or there, or if you're an ICE detainee or a county detainee, this is how we treat everyone at Pinal County Jail. We heard about frequent lockdowns, frequent cell searches, limited access to reading materials, confiscation of reading materials, people not being allowed to keep food, even food that they purchased in the commissary with their own money, and then refusing to transfer detainees who had been held at Pinal County Jail for a long time to less restrictive facilities. So we read the detention standards, and we talked to people in the jail, and we explained that if they had been detained for longer than a certain period of time, 8 weeks, without outdoor recreation, they could request to transfer to be placed in a less restrictive detention setting. And folks did not know that they were able to request those transfers, and then the people who did know they could request those transfers were often rejected. So folks would ask for, I've been at Pinal County Jail for 3 months now, or 9 months now, and I'd like to go somewhere where I can have outdoor access. And the requests were denied or ignored, never responded to. The same for contact visits. We had been told repeatedly by ICE officials, well, if a detainee just puts in a note and asks us for a contact visit, we'll accommodate, we'll do everything we can to accommodate a visit with family members. And again, many of the detainees that we spoke to did not know, were not aware that that was even possible. But then again, many of the people who did request such contact visits were denied. And again, often without reason, or that their request was never returned to them with an acceptance or a denial either way. So these are, just again, like many of the things that have been ongoing problems at the jail, things that clearly do not conform with the federal government's, civil immigration reforms, with the statements, and so what do we do, right? So what as a community of people, we hear from my husband, my mother, my father, whomever is now being detained by ICE in Florence or Eloy. Increasingly we hear this in Phoenix and Tucson and in Arizona. And so what do we do? And it's tough, because you have to figure out what's going on inside and bring that to the outside, and then have families and community members advocating for what kind of change. And so through a long process of meetings with community partners and organizations and impacted individuals, we really felt like it was important to just call for the termination of the contract, and that the jail just had to be closed. That there was no place for this particular jail to fit in under any type of reform efforts by the federal government. And so, and again, this was meetings and coalition meetings, and also hearing from folks in the jail. And at one point over the past 2 years, we would just get tons of petition letters from people in the jail, explaining what the conditions were, explaining what the problems were, signing onto the letters. And I think in all, in the last year and a half, probably something close to 500 petition letters from people who were detained inside of Pinal County Jail. So that's sort of the advocacy piece that we've kind of come to through, at least I have come to, the ACLU has come to with lots and lots of other people in the state of Arizona, is that this particular jail has gotten to the point where there really are no modifications or reforms or litigation, frankly, that may change what that jail is. And so the only logical thing is to call for the jail to be terminated and for there to be no ICE detainees at that jail any longer. I would just say, sort of to answer just 2 quick questions about who is at the jail. So we had, we requested in March of this year some numbers from ICE about Pinal County Jail specifically. And at the time, it was approximately 200 detainees. So roughly half of the population that was there was about 425 people in in the jail in March of 2012. Approximately 200 of those detainees had been held at the jail for 8 weeks or more. And then, of course, we had, through our interviews with various detainees at the jail, we had identified at least a dozen people who had been detained at the jail for a year or more. And certainly that's, anecdotal and based on, interviews, so not based on any specific numbers that the government gave us. But we have also, as I mentioned earlier, been contacted by people who had been detained at the jail for 3 years or more, and had also been denied requests for transfers or other requests. So just by way of some numbers, and to give a sense of how many people are impacted at this point by the conditions of the jail. No longer there anymore, thank goodness. But if you want a copy of the executive summary, they're out on the table. Thanks.
Thank you so much. I just want to make one note before I turn it over to Greg that Victoria's descriptions of what's going on and what's been going on for many years at least in Pinal County raised the question for me, to what extent should we be talking about what civil detention looks like, about the concept of civil detention and what those conditions might be, when it's so clear that there is a problem with compliance with existing corrections-based standards at facilities that are currently being used for ICE detainees. So something to keep in mind, and I'll turn it over to Greg.
Thank you. Well, again, my name is Greg Cook. I am an architect in St. Louis. I work for HOK. We're an international firm with many areas of expertise, one of which is justice. I think we've been active in justice design for more than 50 years. So there's a lot of experience at HOK that we've been able to bring to the industry. Now personally, I don't have as much experience with ICE facilities, but I do have more experience with criminal detention facilities, and that's sort of what I'm going to talk about. But I think what we've learned from our most recent efforts there are certainly applicable here, and after hearing Dodie speak, I think there's a lot of sort of cross-pollination. I think actually most of the stuff I have on my list here I could cross off because you've already mentioned it. But like I said, my experience is more with criminal detention, and one thing that you mentioned, Dodie, was the idea of a normalized design or normative design. And the first step in that is actually the direct supervision model that you also mentioned. And for those of you who don't know, that's actually where the correctional officer is out in the space with the detainees, and that's to encourage a lower stress environment, interaction between staff and inmates, and generally, like you said, create sort of a normative place. The other thing you touched on were finishes and colors, and I think that's a great place to start. And for most facilities, that's really all that they can do is repaint a wall or buy a new chair. For us, we've been able to actually design some facilities from the ground up, so we can think about bigger ideas. And the three big ones I'd like to touch on are scale. I don't know how many of you have actually been to one of these large facilities, but they are enormous. And the housing units themselves can also be enormous. So all the efforts that you take to create this normalized environment just go away because you've got 120 people in your living room. And there's certainly nothing normal about that. The quality of light, I think, is important. Jail standards actually specify the quantity of light that's required, not the quality of the light. And Marco, I think maybe you could speak to this later. So we've taken a great effort to introduce as much daylight into these housing units and the other spaces of the facilities that allow daylight to change over the course of the day, and people to experience some bit of the outdoors, even if they're not actually outdoors themselves. And the other is sound, and that's actually probably the most challenging because just because of the nature of what they are, these are really hard environments, and to increase the acoustical performance in those spaces, you have to spend a lot of money on finishes that are often just unavailable to these facilities. So I think sound is really critical, and it's a real challenge, especially as you get into these larger units with 100 or more people. In my opinion, really the best way to address all three of those issues is through programming and allowing people to move through the facility. So letting people leave the housing unit for periods of time, and whether that's to go to a classroom or to go to a gym, or ideally to go outside and be able to spend some time in nature. I think that's a great solution, and we've had success with that, particularly with the new penitentiary in Iowa. It's a men's maximum security facility. All the programming is actually away from the housing units, and that was intentional. That's to get the people out of the housing unit every day. So when they go eat, they have to go out and walk across a quad and get their breakfast or lunch or whatever. And the same thing for programs and industries as well. Because it's proven that just being outdoors, being in nature, and having views of nature has a real therapeutic effect on inmates, and relieves tension. And another thing it does, getting the people out of their housing units, and we hear this from staff a lot, is they deal with boredom a lot. And when people get bored, they get agitated. So what they want is they want these people to be active during the day. And so that's another benefit of that as well. Both the Iowa State Penitentiary and another facility that we've been working on in Arkansas have gardening programs. And Iowa's is actually long-standing. Their facility now, they have rose bushes and all these beautiful plantings within this massive wall that was built in the 1830s. And they're actually going to take that to the new facility. And we've introduced some natural landscape elements, and we really challenged the DOC there with allowing us to let grass grow taller than 9 inches, things like that you don't normally see in a prison environment like that. And then in Arkansas, they're actually going to introduce more of an agricultural gardening program. That's to keep people active, get them outside, and sort of lower the stress in the environment. The quality of light is important not only for the people that are detained in the facility, but also for the staff that work in the facility, because many times they're there for their entire careers. And it's shown that access to natural light has great health benefits and therapeutic benefits as well. We've spent a lot of time focusing on the areas in the facilities that we deem as the highest stress areas. And those tend to be the intake area and visitation. So those are areas where we're really working to just create that normalcy before they actually even enter the facility, or while they're meeting with family, which, as was mentioned before, can be a stressful event. An area where we haven't made the strides that I would like to see would be in alternative construction, which is related to finishes, and that's instead of a concrete block wall, you've got a drywall or something behind us, and that's something that we always talk about, but it never happens, and it falls back on durability issues or safety, and so there's probably some opportunity there, especially if there's a facility that's dictated as just a civil detention facility. There would be opportunities in dormitory settings and whatnot to use some more residential type finishes other than, carpet or something like that. I think just to conclude, say that as designers, at about halfway through the design process, we tend to create what's called a project design manual, and that's kind of our last hurrah, where we get to load up a book with all these beautiful renderings and diagrams and narratives about all the great things that we've done, and inevitably we hand that over to the client and it gets sent back to us, and many of the things that we're most proud of are actually crossed out, because there's a fear that if the public sees what we're actually doing in these facilities, they're going to react negatively to it and say that it's like a coddling environment or something like that. And I know there's a speaker in the first session that sort of touched on that, or there was a question, I think it was from you. How do we change that mentality of the public? And I think it's a real challenge. I don't have an answer to it, but it's a real challenge. That's really...
On that note, how do we change the mentality of the public? Thank you very much. I have a bunch of questions, and I'm guessing that you all do too. One other thought that strikes me listening to Greg emphasize that there are limits to what you can do to shift existing facilities. You can paint a new wall, you can maybe shift out the furniture, you can change some of the policies within the facility, but constrained by the physical plant of the existing facility. And you really need to build from the ground up to create a new model. And I would just note, we've seen this in the past few years as ICE has tried to do just that. From advocates' perspective, when you talk about building new facilities, there is a fear that inevitably that will lead to increased levels of incarceration. If you build a facility, the government will find folks to fill it with. And that's a tension around this discussion. So, with that, first I think I'd like to ask Victoria and Dora both, and anyone else who has comments. The case law on civil detention seems pretty limited, and you know, the Victoria spent some time talking about Pinal County and the efforts that ACLU and other members of the community in Arizona have made with ICE to try to get conditions improved, shifted, and finally, you know, are attempting to just say this facility needs to be closed. ICE needs to stop using it. The ACLU actually recently over the summer sent a letter to ICE basically laying out the legal arguments for why Pinal County is not appropriate for civil immigration law detainees. And in reading that letter, which is posted on our website, I don't think we have it actually printed out, I was struck by sort of the limited vision that case law seemed to allow for civil immigration. And the most striking example was that right now folks family and loved ones visiting detainees at Pinal County, as Victoria was describing, can only visit via video. So even if they're in the facility, as I'm sure many of you know, they don't actually see the detainee face to face, but are looking over a TV screen. And the letter from ACLU argues that that's unconstitutional and sitting on either side with phones. That doesn't seem, I mean, that's better for sure, but that doesn't seem all that great either. So I'd like to hear from you all of your thoughts on sort of the limitations of case law in this area.
It's very limited. Yeah, no, it's limited, right? It doesn't really get us to the place where we can say this is an abusive environment and should not be permitted, period, the end, right? So it only gets us certain gains, limited gains maybe, and being able to facilitate some of the needs of the folks who are in the jail, but I don't think it gets us to that ultimate place where when individuals' dignity and rights are respected and that they're able to, and even, you know, beyond that, able to really fully participate in their legal cases, in what they need to do in the court to either prepare a defense or explain their defense, right? So the law doesn't get us, I think, ultimately, at least here in Arizona, where we've come to with Pinal County Jail, where we would want to
tend to spread out some more. If you opt to do more than the minimum, you always have to still build in the provision where something more restrictive is needed. And so when you opt for contact visits, then you also need to create space for non-contact visits. And so that's just a reality that systems grapple with in different ways. Having said that, it's also been my experience, it's how you do things that has a lot to do with how they are received. In in jurisdictions like state prison systems where people are assigned to correctional facilities some distance from where their families are and visitation is a hardship, that's true on the civil side as well, where they have created Skyping types of opportunities, that is frequently seen as a very positive thing, particularly with kids who are Skyping back and forth with their friends and relatives on a routine basis. For some of us who are technologically not there, or for some another generation, it's perhaps experienced as an artificial or an unpleasant experience. So it has a lot to do, as I hear you describe it, the quality of the way in which you communicate. You have bad visibility, bad audio, and probably an inhospitable environment in which it's all occurring. But these things can be done differently and achieve a better result. It's at the end of the day, it's taken corrections some 40 years to build up case law robust enough to really give good guidance. And it would be unfortunate if we waited another 40 years to pursue the same means, litigation, to come to us to a similar, hopefully better result.
So what's the alternative to the litigation?
Opting to do more now. There's nothing wrong with voluntary.
Yeah, I would also just point, right, one of the things that we talk about with Pinal County Jail specifically is that the jail was constructed with the ICE contract already in mind. And so the jail and the county already knew that they had a contract with the federal government to have this wing of the jail dedicated for civil detention for folks who were going through immigration proceedings. And despite knowing that they had this contract, the jail was rebuilt and the wing was reconstructed without any modifications or any, maybe not even any discussion, I don't know, about how it should be different from, from the pretrial detention side. So yeah, having those discussions and being able to talk about what the civil detention model looks like and what the existing structures are. I mean, at this point, it does not seem likely that the Pinal County Jail could be modified in any way to really meet some of the civil detention pieces that we're talking about, like increased outdoor access or increased contact with family, or being able to walk outside for programming. So that current jail structure just would not lend itself to being modified in those ways.
But it sounds like it doesn't meet the minimum standards that are promulgated by ICE, whatever year standards there were at the time.
Well, it's also one of the issues, again, that we've probably talked about, is that, so the jail is actually on the 2000 standards, and since then there have been 2008 standards and 2011 standards now, but the jail is allowed to contract and remain on the 2000 standards. But even, as we point out in our letter, they don't even meet those 2000 standards, specifically on the outdoor recreation piece.
Turn to the audience. Marco.
It's for Victoria. Victoria, do you think he had no solution for PCJ?
A solution?
Yeah. You think the immigration calls the PCJ one day? Because it's very hard. I've been doing that for 2 years and I know.
Yeah.
I know.
It's you should come to one of the coalition meetings that we have where we vigorously debate, whether closure of a facility is a real goal, and I think it is. Otherwise, we wouldn't have put it on the table, and I think that it, like I said, just hearing from people inside the jail, and from family members who have loved ones in the jail, it really, I think, it came to us that really asking for closure of the facility or demanding closure of that particular jail was really the only option. So, yes.
Okay,
I have a couple of questions, and they're probably going to sound really simplistic to you, and I don't mean to sound because I really don't know. So they're not meant to be, please indulge me. I only know the criminal side. I don't know anything about civil law. But I'm really having a hard time understanding this. I know from pretrial detention on the criminal side, we detain people because we are determining whether they are a risk to appear for court appearances or they present some type of danger level to the community. So, hearing what we're doing on the civil side is we're looking at your risk to appear for court appearances. Is this law predicated on the assumption that if you are in this country in a non-legal status, we have to detain you because you're not going to show up for court? So the only way we can get you to take care of your immigration matters is you have to remain in a detention status? That's what I don't know. Is that basically what the premise is?
Like, I think that ICE would need to respond, but
Well, there's the most recent of the immigration reforms from 1996 identified a number of situations that trigger mandatory detention, but ICE has reported at the forum, certainly in Austin and in other publications and testimony to Congress, it has many individuals in the community, either on bond or on personal recognizance or on community supervision. But again, Congress has appropriated considerable monies to detain those individuals who, this is where I'm going to start to paraphrase, who must be detained vis-a-vis the federal law. But also, ICE has promulgated its own guidance about the prioritization in which it will take people into its custody and assign them to detention facilities. And they've described priority levels 1, 2, and 3, the kinds of criminal histories that fall into those things. I can't speak as specifically about. They change somewhat over time. Ruthie may have something more.
So when we're looking at, and as I said, this is very simplistic, so bear with me, because
this is the
when we're looking at the push in the reform in the criminal justice system to do everything evidence-based and based on validated risk assessments, are we looking at on the civil side to say, should we, even when we start this discussion, be looking at this population in terms of looking at a validated assessment, to be looking at detaining people who truly pose the risk that they won't go through this process unless we detain them? And those are the ones that we in fact should, because I keep hearing about we need to build facilities or we need to have alternative services. And when I think about services, I go back to that where we have the discussion about, where we have either pretrial services or probation services or whatever else, rehabilitative services, as opposed to really, in this light, what you're really having are adjunct services of counsel and either a social service or a call to court or a reminder agency to massage people through the court process. So it doesn't even look like a whole infusion of dollars to have that outside service. So is there a discussion of kind of overlaying that same evidence-based model on the civil side? And as I said, this is really simplistic, so
to some extent there is. Again, if you're in a mandatory category, you're in a mandatory category. There is no discretion that can be exercised. Depends on the group. As I mentioned earlier today with asylum seekers, when you can establish a credible fear, at that point you can be considered for placement. There are others that don't fall into the mandatory category. And one of the recommendations report, one that has, many have been adopted, this one has actually been fully achieved and was in the process of being, it had been field tested, it was being rolled out, the risk assessment.
Didn't roll out.
So it is an evidence-based objective assessment of risk of flight, failure to appear as scheduled, and it now is increasingly being used to inform decisions about not only who is appropriate to be placed or kept in the community, but every bit as importantly, we talk about this whole continuum of control, is how much supervision in the community is needed, because some of the prior criticism had been that there had been over-reliance on electronic monitoring more than risk would suggest. And so this instrument helps ICE as it has helped those of us on the correctional side to answer those two important questions. Can they be in the community, and what kind of management, if any, is required to achieve a good result?
This is, I mean, you're getting at some of the fundamental questions, so it's not simplistic, it's just as relevant. So what types of programming make sense for ICE, for individuals detained by ICE? And yeah, folks in the audience might have thoughts as well.
I bring programs into the prisons, and I was a prisoner, so I can speak to it from both sides. I'm also a teacher. I was a high school English teacher, so I can speak to programming in a lot of different ways. It's not the types of programs that are brought into the prisons, it's the way they're presented anywhere. In the Department of Corrections, with all respect to Dora Schriro, because I really admire her tremendously, and she had no control over this, but I think it's pretty universal everywhere. The teachers are the correctional officers that have been promoted to a certain level, and they come in with a really good program, and they don't know how to teach it, and they open the book and say, well, I've got to be here, so this is how we're going to do it, and they read the book. And it's boring, and it is ineffective. And that is, Dodie's shaking her head because she knows, because this is pretty standard. So you can have the shiniest, most brilliant program in the world, and if it's not presented right, it's a waste of time and money. So it's not just the types of programs. You can bring creative writing, you can bring civics, you can bring math, you can bring English, you can bring book clubs, you can do all that. It's not presented properly. And then you get into who's going to do that. My organization depends on community volunteers. And now you get back to the location of prisons. Community volunteers, I have people from Sun Lakes driving to Perryville. It's 100 miles round trip. And then they can get there, the prison's locked down and nobody's called them. And so it's a very complicated thing. But if you just want to get to how it's presented, I think you really address something important. Because you need teachers, not correctional officers. That's not what they do. You need teachers, people with a passion for this. And obviously that's what I have, a passion for this.
I would just also offer that many of the people in immigration detention who would need some type of programming, so people who are actually under the current immigration law, fighting to keep their legal status, fighting to keep their green card, trying to make a claim for asylum, that many of those folks who are in immigration detention who would benefit from some type of programming are people who shouldn't even be in detention to begin with, because they have community ties, they have families, they have trauma or psychological issues from fleeing their home countries. And so again, just sort of putting the cart before the horse, or the horse before the cart, or whatever the saying is. All right, so when we talk about programming, if you're talking about parenting classes, for example, maybe Cindy already talked about this, right? But if a parent is in jeopardy of losing their child, should we be offering programming to that person in a civil detention setting, or should we be making some type of accommodations to allow that person to be released from detention so they can do their parenting classes or whatever's required of them outside of a jail setting?
Any other comments from the audience?
For programs, I think it's the best programs can have in detentions. The first one is English, the ECL, okay? The second one for the legal advice, because say, okay, you have the law library, okay? You open the door, you scan. Now, because I have too many books, never see the law books. I don't know the immigration law. Okay, you can use it. How I can use it? You know, it's crazy. Okay, you can appeal your case. You can make yourself your case. But how? How can you make a petition? I don't have a sec for making the petition. You know, this is, I think, the first one the judge can get in the detention. The second one, I think, the full period and the manager, the drug addiction, and what else? You know, but I think the first one, I think, is Excel and legal advice.
So ESL, legal advice, and then you said
computer
training.
and manager, drugs addiction. I think in my opinion, you know, because first time you say, oh, you can use the law library. I open the door, oh, it's very nice, books and books and books. Okay, where is that here? You know?
Okay. Well, on that excellent advice, thank you all so much to the panel for we're running behind, obviously, in our schedule, so I think we'll break for 30 minutes for lunch, and so come back at 1:45-ish.